trademark applications are insufficient to establish trademark rights under the UDRP, the Uniform Domain Name Dispute Resolution Policy, and a failure to provide relevant evidence of trademark usage is fatal to proving common law trademark rights under the policy. Those are two very basic but important reminders in a short but very helpful UDRP decision that was just recently published. The decision is so short that it says nothing about how the complainant was using the disputed domain names 0456.com and 9527.com, other than a reference to the fact that the complainant and the respondent were previously partners in some sort of unidentified business using the domain names. The case was filed at the forum in January 2022 and decided less than a month later, a very quick timeline even by UDRP standards. Although it's unusual for a UDRP dispute to involve domain names that contain only numbers in the second level, that was not the problem here. In fact, there are a number of previous UDRP decisions with so-called numerical domain names, such as 7-11.co, which was won by the owner of the 7-Eleven trademark, used in connection with convenience stores, and multiple complaints filed by Cube, a British company that provides betting products and services in connection with the trademark 188, and has won UDRP decisions for many domain names that contain 188 plus other numbers. Unlike the complainants in those cases, though, the complainant in the case I'm discussing here lost its UDRP decision because it was unable to prove to the panel's satisfaction that it actually held any trademark rights. And that's the first and most basic issue in any UDRP proceeding. Because the first element of the UDRP requires a complainant to show that the domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights. In most cases, the focus is on the identical or confusingly similar language, but that element contains a threshold requirement that the complainant actually have trademark rights in the first place. In most UDRP cases, establishing trademark rights is straightforward, where the trademark is protected by a federal registration, then citing the registration number and providing evidence, such as a copy of a registration certificate or even a printout from the website of an appropriate trademark office or database, is sufficient. And although a trademark registration is not required under the UDRP, if the complainant doesn't have one, then it does have to establish common law trademark rights, which is certainly more complicated, but is not at all unusual. Here, though, the complainant apparently only had pending trademark applications. Unfortunately, the UDRP decision is so brief that it doesn't even state in what country or jurisdiction those applications were pending, but the panel cited a well-established UDRP precedent. To prevail under policy paragraph 4A1, complainant must prove that it owns valid trademark or service mark rights in marks to which complainant contends the disputed domain names are identical or confusingly similar. As evidence of such rights, complainant asserts that it has pending trademark applications for the marks 0456.com and 9527.com. However, the panel notes that the consensus among prior policy panels is that mere pending trademark filings fail to constitute ownership of a mark for the purposes of policy paragraph 4A1. So then the panel moved on to address whether the complainant might have common law trademark rights. And the panel quoted from the WIPO overview, which says that a complainant must show that its mark has acquired distinctiveness or secondary meaning, which can be proven by providing evidence such as the duration and nature of use of the mark, the amount of sales under the mark, the nature and extent of advertising using the mark, the degree of actual public recognition, and consumer surveys. Now, I've successfully made this argument many times in UDRP cases for my clients, and I always include detailed information backed up by significant evidence showing how the mark has been used. But apparently the complainant in this case didn't do any of that. The decision, in fact, refers to the complainant's evidence as nothing more than brief jottings showing that the domain names had been used for less than 4 years each, had generated only about $2,000 to $3,000, and that they had attracted only about 200 to 300 visitors. So here's what the panel wrote on this issue. In evaluating this sparse data, the panel concludes that the relatively meager revenues and advertising expenditures, together with the about 10 website visits or less per day within the relatively short periods of operation, do not come close to constituting the substantial body of evidence necessary to sustain a finding the complainant possesses common law trademark rights in either of the claimed marks. So the bottom line is that the complainant in this case failed to meet the minimum requirements for the first part of the UDRP's three-part test. And so the panel denied the complaint, allowing the current registrant to retain the domain names. The lesson for trademark owners, or would-be trademark owners, is made clear by this decision. Don't file a UDRP complaint unless you have an appropriate trademark registration or can establish common law rights under the UDRP's criteria. Simply using a domain name or filing a trademark application does not by itself create any trademark rights. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.